everybody. I'm Paula Rome from Julian Taylor Solicitors, and I'm here today to talk to you about employment status. Couple of angles that I'm going to look at as we talk through that. The first, which is my main area of interest, is around employment rights, and that has been widely discussed over a number of years in relation to this sort of division of protections for individual. And high on this year's agenda as well is the tax implications. And I've talked with colleagues about this over a number of years now, and even amongst employment lawyers, there's a bit of a surprise that you've got two regimes looking at very similar things, but with slightly different systems, which causes its own complexities, which we'll look at as we go through. So starting off, and I'm hoping you can see the slides, and these slides will be available if people want them. I'll mention that at the end of the session as well. So different tests for employee rights and tax. It does add a level of complexity to the situation, but why do we look at this situation to begin with anyway? And this is because the gig economy, and that's a phrase you've probably come across, it was certainly all over newspapers before COVID, and 2 or 3 years before the COVID situation slightly changed our emphasis. The gig economy was a very high profile political issue, to such an extent that we had a full blown report considered and published called the Taylor Report. And the Taylor Report was quite controversial in its own right, the union saying it didn't go far enough, other organisations and employer organisations saying it went way too far. But actually, it wasn't as contentious as you might have thought, and a lot of its included guidance was really sensible. And what it called for was greater clarity around employee rights and workers' rights, so that people who are working know what they're working to, and ideally what money they're going to get at the end of the day. So Taylor was calling for clarity around pay and hours, and on our next slide we will see that has already led to a slight change in legislation. The Employment Rights Act now calls for workers as well as employees to be given terms and conditions when they join an organisation. That is simply for new workers. So if you've got existing workers, that won't impact on you unless you change the basis of their working, in which case you will have to give not just your employees, but also your more casual workers a breakdown of terms and conditions, particularly so that they can work out what they will be paid at the end of the day. And that was one of the problems with the gig economy. If it was limited to those individuals who are highly paid and who know what their rights are and are highly skilled and can set their own hours payments, then it wouldn't be an issue. But the problem that's happened is that with the uncertainty that goes along with short-term, uncertain jobs, also that's being connected with low pay. And that of uncertainty with low pay has meant that individuals are potentially vulnerable, and it's not your high paid, high skilled individuals where that vulnerability lies. It's your low pay, low skill workforce, and that percentage of the workforce on not full-time hours, not always guaranteed work, are where the abuses in the system started showing, which in turn led to governments saying this is something that needs to be looked at. Added to that is this new technology that we have around workers, and particular Uber, Deliveroo, those people who just log into their phones or computers and are assigned work through that system. Where do they sit in this sort of worker and employee status? And certainly both on tax and employment, that is one of the areas that has led to a huge amount of debate. So why is there this complexity around tax and employee status? It's because we have different tests slightly. Tax only sees people as employees or self-employed for tax purposes, whereas with employment rights, we've got a third layer of protection. So we've got our employees are genuinely self-employed, and a grey area in the middle, which is the worker. And as time and legislation has been drafted, especially the legislation that's come from Europe, it clearly envisages that there is this new type of creature, this new individual who is a worker, who is not without rights, but doesn't get the same level of rights as employees. So if we look at that in more detail, we could almost say that your employee is your fully comp individual, in that they've got full cover. Certainly after 2 years of employment, they've got the really valuable rights of protection against unfair dismissal, the right to have a redundancy payment. They also get TUPE protection. So if businesses are bought and sold, the employees get protection in that situation. Though interestingly, and this is a bit of a sign of the time at the moment, there have been some recent cases which has set up a bit of a debate about whether workers get that protection under TUPE as well. It's not definitive, and the legislation certainly limits it to employees or those providing personal service. And that's where the question over workers comes in, if they're seen as giving a personal service. Also, employees have Sunday working protection. If you work in shops or betting shops, there's a level of protection there that only employees get. As well as those top level protections, employees and workers get protections such as minimum wage and holiday pay. And those two areas are what have led to a number of employment tribunal cases, which you've probably read about because they were high profile. Also now, as I said, there's been a change to the Employment Rights Act, which says that the Section 1 terms now are given to workers as well as new workers, as well as employees. Whistleblowing protections are for workers as well as employees, as indeed are GDPR, data protection rights and discrimination rights. Those last two rights are really the only rights that contractors get, because you're genuinely self-employed contractor running their own business, quite often for their own profit, protecting themselves. They're not seen as needing the employment or the worker protection in the same way. So they are sort of the lower level of protection when it comes to the employment rights. So in the workplace, certainly over the last 20 years, we have seen a great deal of thought being given by employers as to how they can maintain the maximum amount of flexibility in their workforce. There is more use of agency workers, your good old-fashioned temp who comes in, casual workers, 0 hours, which are not without their critics, bank workers who were supplied to you, seasonal workers, those with minimum guaranteed hours, short hour contracts, as well as your self-employed freelancer, your independent contractors and your consultants. So you can see there's an awful lot of different types of worker in the workforce. And for employment rights and indeed for tax, they all have to be fitted into a category, because in employment rights, you only have those 3 categories: your employee, your worker, and you're genuinely self-employed. And for tax, it's even trickier because tax only recognises your employees and your self-employed person. So it is a good task to go through, I think, for employers every now and again, just to look at what you have in the workplace. Because I know I sometimes talk to HR and managers and they use the word, oh, well, they're casual, as if that's some sort of protection. It's really not, because at the end of that relationship, is that casual worker suddenly going to start asking for rights as an employee? If they've been there for a long term, over 2 years, then they may well be saying they've got those unfair dismissal and redundancy rights. So that's something you need to think about. And also, of course, what you don't want is the Inland Revenue looking at how you're paying people and saying, well, actually, that's not appropriate. We think that this genuinely self-employed person that you're telling us is genuinely self-employed actually is a disguised employee, and we want the tax, the PAYE, and the national insurance for that individual. And frustratingly, to make things even more complex, a tribunal can reach a decision that says, no, they're not an employee, they don't get employee rights. Whereas a taxman can look at the same situation and say, in our view, for tax purposes, we think they ought to be being taxed as an employee. So you can get differing decisions from differing forums, which is not ideal. So when it comes to unfair dismissal, redundancy, those employment type protections, what do the tribunals look at? And the tribunals have what we call the irreducible minimum. And those are 3 factors that must be there for it to be an employment contract. And that is that there is personal service. So that person comes in, they do the work for you. They are not allowed to send a substitute in their place, which is, of course, one of the key tests that has emerged. Also, you have a level of control. They are subordinate to their managers or to the business. They have to do what they're told. And mutuality of obligation. And this has always been a crucial test for the tribunals. They will look at it and say, is there a duty on the employer to provide this individual with work? And is there a duty on that individual to carry out the work? They can't just say, no, I don't feel like it today, I'll go and work for someone else instead. That, if that happened, that would be a very, very strong indicator, if not determinative, that this was not an employment contract. There are, however, these grey areas that we've seen going through the courts and tribunals recently between particularly the workers and the self-employed. This has been because, and it's not all the fault of employers, there has been sometimes an agreement between end users and individuals that for tax purposes, it would be so much better for everybody if they were genuinely self-employed. And that's, of course, because the employer is not facing the increased national insurance of 13.8% of the payroll if they're genuinely self-employed. And the tax regime for individuals is marginally better. And of course, if the end user, the employer, is not paying the 13.8% for national insurance, who knows, maybe that's increased to the top line that the individual's earning, if they're very lucky. So there is that element in the workforce itself. But as I said, politically, there's been this swing towards giving individuals protection, particularly when they're the low pay individuals, and this can be abusive to them, which has led to that run of cases that I've mentioned, the Uber, the Deliveroo, the Pimlico Plymouth Pimlico Plumbers even case. And looking at the Uber case, just because it's the most recent, what the tribunals looked at in that case were the level of control that Uber had. They dictated the rates for the drivers. The contract itself was quite controlling in that they could say what sort of cars, indeed what colour car, the individuals needed to have to be accepted. If the drivers failed to accept fares, they could effectively be penalised, or could we say disciplined for doing that? And eventually, if they've logged on but they're not accepting or refusing a number of fares, they could be taken off and not allowed back onto the app for a number of days. So because of that level of control, the tribunal said this looks far more like a worker rather than a genuinely self-employed person. Further, they said because of the restricted contact with the fare the individual picked up, it wasn't like your traditional taxi driving service, which quite often is seen as a self-employed worker in that situation. But they said the level of control that Uber had certainly indicated that these were more likely to be workers than genuinely self-employed, which gave them the protection of minimum wage for all of the time that they were logged onto the system. And that last bit was a bit of a surprise. Also, of course, as well as minimum wage, they got the holiday rights as well. So levels of protection there for the individuals that the courts give. And there are those financial benefits and job protection that the individuals get as a worker that they don't get if they're genuinely self-employed, which of course is what their employer was trying to argue. Tax is different. It's got to be said. For tax, we have a more regimented and settled list of considerations. They'll sound familiar because they cross over massively with the employment test. Your taxman, when he's looking at the situation, he is going to be looking at, is there personal service? Is there mutuality of obligation? What's the level of control that the payer has? Is the individual recruiting their own staff, because they're more likely to be seen as self-employed if they have their own employees? Do they use their own equipment? What is the financial risk and or benefit that they can gain out of this? So if you are running an organization, you are genuinely self-employed, you have employees, you can send people in your stead, you are running your own business rather than working in the offices of the organization which has hired you, using their laptops, eating in their restaurants, in their facilities, and under the close management, being told off if you get things wrong, being expected to be there 9 till 5. If it's the latter, you're far more likely to be seen as at least a worker, possibly even an employee, for tax purposes. This has always been an area of debate for tax. The original IR35 came out in 2000 to try and deal with the situation where individuals were working for their own personal service companies and decided, oddly, that they were self-employed, which saved them a massive amount on tax and national insurance. The government brought out IR35 to make those individuals in their own companies look at the situation and assess for themselves whether they were genuinely self-employed. There was an initial flurry in the year 2000 where a few people and few organisations did declare that they were more likely to be disguised employees rather than genuinely self-employed. But since that time, there has been a massive increase in personal service companies, but no similar massive increase in declarations that they're employed rather than self-employed. So the government's decided that this was not working, and the change was supposed to come in last year for personal service companies, but because because of COVID, was delayed until this year and is now in force. But it's changed the emphasis. And what it said is it is the end user of the service. So the company that the individual works for who has to decide for tax purposes if they're an employee or whether they are actually genuinely self-employed. Now, the new rules which are in place don't apply to small businesses. And small businesses, it's on the next slide, but I'll run through it now. Basically, are businesses who are making not more than 10.2 million in turnover, 5.1 million on your balance sheet, and you don't have more than 50 employees. And if you can comply with 2 of the 3 of those, you are held to be a small employer. What I would say, though, is that doesn't get you off the hook, in that if you're in a chain supplying service of individuals, because it's the end user who has to make that determination. If they're a large employer, then they still have to make a determination and may be contacting you to ask you about the organisations, the individuals you have within your organisation who supply work to them. And we've definitely had a few emails and phone calls about that, where even small employers or small businesses have had to look at this and say, well, do we think these individuals that we're contracting with are genuinely self-employed, or will they be seen as a disguised employee of the end user? So don't be overly surprised if you get contacted. HMRC have said they are going to introduce this on, as they call it, a soft landing. So they're going to give you a little bit of a time to look at your workforces and just work out what you've got and are you treating them correctly. But at some point they are going to start coming back to you and asking whether the correct tax regime has been followed. I've put agency workers down there as well. And just to emphasize, agency workers under the regulations have always had a separate taxable status, in that if you get a good old fashioned temp through an agency, even if they're seen as self-employed by that agency rather than an employee of the agency, which is actually the most common these days, they had to pay PAYE and national insurance. It's set out in the regulations to prevent abuse of tax in that situation. So they have their own separate rules. But any of the other individuals who are being supplied, there has to be a determination of their status. How do you do that, you ask me? The government have put in place what's called the CEST tool, and that is check employee status for tax. It does what it says on the tin. There's criticisms of that tool. It's a bit broad. Quite often when we've run people through, it's come back with an undetermined status. It assumes that there is mutuality of obligation. So there is an obligation by the organisation to provide work, and an obligation if asked to do that work on the part of the individual, which is actually one of the key tests. So it's odd that that's included as an assumption. The good thing about the CES tool, though, is if you honestly put your information in and it's processed and it comes out as not employed, then HMRC will honour that. Other products are available, but they're not recognised by HMRC. There has also been quite a lot of insurance offered in relation to this. Worth looking at the insurance you've already got, because it may well cover HRMC assessments under existing insurance, and all insurance will only protect you if you've been doing things properly. So it's not a cure-all. You can't just say, oh, this is all too complicated, I'm not going to look at this and I'm going to rely upon the insurance to protect me, because it won't in that situation. There have also been this sudden creation of or certainly increase in the number of what are called umbrella companies who will provide you with the services of individuals. Some of these companies have been very, very naughty in that how they are paying people is they are reducing the amounts that they pay the individuals who use their services, in effect, to reclaim the holiday pay, the minimum wage issues, and the national insurance. That is not lawful. And if it's an end user, if you're in that situation and you are aware they are doing that, that could cause problems with you as well, with HMRC. So do be careful with the insurance and the umbrella companies, that you vet them properly and make sure they are a genuine organisation who are not going to get you into trouble. So looking into the crystal ball and trying to assess what's going to happen here in the future, I think we have seen a direction of travel in that the level of concern for low pay workers who are in work but still in poverty, that's an increasing worry in the political surrounds of this. And although there will always be pressures by employers for flexibility, which I totally understand, unfortunately, the number of abuses of low pay workers, I think, will lead to a situation where greater and greater protection is given to the low paid gig workers, which is going to narrow the protection between employee and worker. And I think we will be seeing more protection for workers in this sort of situation because of that worry about the abuses. And last week there was a lot of publicity around a couple of reports which were handed down, and I've put the link into the second one and mentioned the first report. And unfortunately, what has been found is the effect of COVID has been particularly harsh for those people who are part-timers and flexible workers, disproportionate impact on them. About half of all part-time workers were furloughed, whereas only a third of full-time workers were furloughed. And also there was a slower return to work for part-time workers. Between the lockdowns, only 44% of part-timers were sort of returned to the workplace, whereas I've got those numbers the wrong way around, I think. But basically 33% of the full-time workers were welcomed back, were not welcomed back, whereas 44% of the part-timers were not welcomed back. So the impact was that the furlough had a bad impact on the part-timers. More part-timers were furloughed, and it's slower to get them back into the workplace as well. All of the smart money seems to be on the part-time workers. That is going to be mirrored again when we start getting everybody back to work. So there will be a move, I think, to more protection for part-time workers. And there's already calls in a lot of publications for extra protection, and that any flexibility that comes out of coronavirus isn't just around place of work, but also hours of work as well. So it's not easy. The best ideas to look after yourself is make sure you know what your workforce is and do a regular audit, that you are aware of what people's rights are and you're giving them those rights, and also you have considered how you should be taxing individuals. And like I said, you may also have third parties. If you're providing individuals into third parties, you may well get communications for them asking for information about the workers so they can carry out the assessment and declare for their purposes whether they believe the individuals are employed or self-employed. You can challenge those. That's beyond the scope of really what we're talking about today. But if you do need any further information around any of that, please do contact us at Julian Taylor. I'm Paula. If you want copies of the slide, then do let me know. My email address is paula@juliantaylorhr.com. And thank you ever so much for having the time, taking the time out to look at this today. And I hope that has made you feel slightly more knowledgeable and less scared around the potential risks in this area. Thanks ever so much. Bye.